Good afternoon, everyone. I hope we are all well. Thank you so much for coming on today. And it's that time of the year, that time of the week again, when we gather here to educate ourselves on everything properties and the mortgages. Now, today we have a special one that we're going to be discussing, really, which a lot of people have shown interest in already because it affects a lot of people in this country. And we are talking about Tenancy Deposit Protection Scheme. So today we're going to be talking about the rights and obligations of both the landlord and the tenant when it comes to protecting your deposits. There are things that you as a landlord need to know that you have to do. There are things and rights that you as a tenant need to know that you must have and be entitled to. So you got to understand these things so that you know the relationship between you, the tenant, and the landlord or the estate agent will work a lot better. And that's our aim of doing what we are doing, educating and sensitizing every party involved in the properties business so that the relationship will be a lot smoother and there will be a lot more understanding. Because properties, as we always say, is a people's business. If the people involved do not understand their left from their rights, if they don't find a way to harmonize their relationship, the property business becomes a frustrating one. But as long as the people involved are taken care of and looked after and taken seriously, everybody is happy. And if everybody is happy, the property business becomes an interesting and successful business, which is what we try to do here at Modesty's Property Consultants, trying to make sure that our landlords, our tenants, and everybody involved in our properties business, they are all carried along and they are all educated, because an enlightened and an educated client or tenant or landlord makes our job a lot easier, because then we can be communicating at a level of understanding that affords or offers us a mutual progress. So, tenancy deposit protection schemes. There are a few things I just needed to know generally that we're going to talk about the tenancy deposit protection. You see, all tenants in the UK, they have a right to get their deposits protected by the landlord or the estate agent. But that right is only applicable to tenancies that are described as assured short hold tenancies, AST. For all ASTs, right? For all ASTs, you have a right to have your deposit protected in a tenancy deposit protection scheme. So what's actually a tenancy deposit protection scheme? You see, the law states that for every AST, assured short hold tenancy agreement, right, that was entered into after the 6th of April 2007, every deposit involved in that transaction must be protected by paying it into a deposit protection scheme that is recognized by the government. Okay, that deposit protection scheme ensures that the landlord or the agent does not take the tenant's deposit and then start trading with it, start doing whatever they like with it. And then at the end of the day, at the end of the tenancy period, the estate agent or the landlord and the tenant are beginning to have issues about getting their deposits back. So to protect the rights of the tenant and to also draw a clear line between what funds are available to the landlord or the estate agent, the government said every deposit involved in a transaction, in a rental agreement, must be protected in a tenancy deposit protection scheme. So that's how we came about it. So there are a few tenancy deposit protection schemes that are recognized by the government. Some of them are it's called Deposit Protection Service, DPS. There's another one called My Deposits. And then there's another one called Tenancy Deposit Scheme. These are schemes that are recognized by the government, right? And if your deposit is protected by any of these schemes, then you are safe and you are covered. And that's one thing you must ensure as a tenant, that your deposit is protected by a government recognized deposit protection scheme. Okay, now as a tenant, there are certain rights that you must know that you have regarding your tenancy deposit. One of those rights is that you must get your deposit back within 10 days of agreeing how much you are due to get back from your landlord. So what happens is, at the end of your tenancy, right, you've moved out of the property, for example, and I know that, apologies to all those who are on Facebook. The live video on Facebook, for some reason again, this today is not working, but we are going to make it up to you by making a YouTube video, and then we're going to post the YouTube link onto our Facebook page. So apologies again. On Monday it happened, and then we tried to sort it out, and today again it's repeated itself. Unfortunately, these things are beyond our control, but please bear with us. We'll try and see how we can sort these things out, whether it has to do with our settings on Facebook, or we have to contact Facebook to let them know that our live videos are not working. Yeah, so moving on from that, so as a tenant, that's what you need to know. What happens is, at the end of your tenancy, you come to an agreement with the landlord on how much deposit is due back to you. That means the landlord must have taken into consideration whether there are damages in the property, or maybe the cost of cleaning the property if you did not clean the property before you left. The landlord has the right to say, I'm going to get a cleaner in, do a thorough cleaning, and I'm going to charge that against your deposit. Okay, you damaged some cabinets, some windows got broken, some door handles got broken, the toilet seats got broken. You've broken a few things in the house. I'm going to fix them, and I'm going to charge that against your deposit. And then the landlord will say, this is how much it's going to cost, this is how much you're going to get back. If the both of you agree on that, you must get the amount due you within 10 days of actually agreeing on that with the landlord. The other right you need to know as a tenant is that if there is a dispute between you and the landlord, for example, the both of you did not agree on exactly how much the damages would cost, and that dispute remains unresolved, your deposit must remain with the tenancy deposit scheme until that dispute is resolved. Right? The other thing you need to know as your right as a tenant is about holding deposits. Okay, here's the deal. Holding deposits are not the same thing as tenancy deposits. You see, when you want to rent a property, you can pay what you call a holding deposit to allow the landlord or the estate agent to take the property off the market, reserve the property for you while you go through the paperwork, like the referencing, completing the forms, signing the agreement and all that. While all that goes on, you have paid them a holding deposit to say, with this, I commit to renting this property. So take it off the market and, let's go through the whole process. Now, to some estate agents, if in the course of that due diligence and referencing, something goes wrong, maybe you did not disclose that you had a CCJ, and in the course of running that due diligence, they noticed that you had a CCJ. They have a right to say, you are not fit to rent this property because you did not fully disclose to us that you had a CCJ, so you did not pass credit report. We are holding this deposit because you have denied us the opportunity of further marketing this property for somebody else who would have taken it, who would have been in a better position to rent this property. So that's what's our compensation for the time wasting, because you did not disclose this information to us earlier on. And we've seen this happen before, where a tenant came in, wanted to rent a property, had a CCJ but did not disclose it, and then it became a problem and they lost their holding deposit. It's possible. So that's what holding deposit is. The tenancy deposit is the actual deposit you now pay when you become a tenant. Once you sign on that agreement and the tenancy is completed, you become a tenant. that's when you pay your tenancy deposit. So what happens is, with the holding deposit does not have to be protected. In fact, it will not be protected. But the moment you become a tenant, that holding deposit will become a tenancy deposit, and that is when it must be protected. So you've got to understand the difference between the two, so that it minimizes the rift between tenants and landlords and estate agents wanting to get their deposits back. So you know exactly what you are paying. When you are asked to make a deposit, find out and be sure what the deposit is for. Is it a tenancy deposit or is it a holding deposit? So you know what your rights are, you know where it stops and where it starts. So once you become a tenant, that holding deposit becomes a tenancy deposit, and then it must be protected. Now, even if the deposit was paid by a third party, that's the next thing you have to know as a tenant. You're right. Even if the deposit was paid by a third party, it still must be protected. Third parties are allowed to pay deposits, okay? And those third parties, like your parents or a housing association who are paying your rent and you are moving to a different property, or the council are paying your rent and you're moving to a different property, and they want to pay your deposit as well. Even if it's coming from a third party, it still has to be protected, right? Or transferring your deposit from one deposit protection scheme to another, that amounts to a third party paying your deposit. That also must be protected. So it's not only when you are paying the deposit directly yourself, even with third parties, it still has to be protected. Okay, so those are the rights you need to know as a tenant when it comes to deposit protection scheme. What about landlords? What do landlords need to know that they have to do? The obligations of landlords when it comes to protecting deposits. Now, if you are a landlord, you need to know that if you take a deposit from a tenant, you must, it's compulsory, you must protect that deposit. You must take that deposit and put it in a tenancy deposit protection scheme within 30 days of receiving that deposit from the tenant. Within 30 days of receiving that deposit from the tenant, you must put it in a tenant deposit protection scheme. That is compulsory. Now, like we have said earlier on, this law is only applicable to assured short-hold tenancy arrangements. What if that tenancy is not an assured short-hold tenancy arrangement? If it's not an assured short-hold tenancy arrangement, as a landlord or an estate agent, you can actually receive valuables like wristwatches, gold ornaments, necklaces, golden rings, cars, whatever you consider is valuable and is worth the amount of deposit you require. You can actually take that in place of money, and you don't have to protect it because it is not an assured short-hold tenancy arrangement. So that's the difference between that arrangement and an assured short-hold tenancy arrangement. As long as it's an AST, an assured short-hold tenancy arrangement, that deposit that you collected must be protected by the tenancy deposit protection scheme, unless it is not an AST. Now, the other very important obligation that the landlord needs to understand is sometimes landlords use estate agents to rent their properties, and then they think, oh, the estate agent is dealing with everything regarding their deposit scheme, and therefore I have nothing to worry. Sometimes it might be useful for you to follow up the estate agents and make sure and find out how they are protecting your tenants' deposits, because it will come down to you if anything goes wrong in the future. The ultimate responsibility of protecting deposits lies on the landlord, even if you're using an estate agent. Because come to think of it, what happens if that estate agent goes out of business? What happens if that estate agent ceases to trade? The tenant is still your tenant, so the deposit that they have put down still had to be protected. So if the estate agent did not protect that deposit properly using the proper channel, the onus is on you, the responsibility is on you, the liability is on you as a landlord to ensure that that happens. If that doesn't happen and the estate agent goes out of business, the tenant will take you to court. And the tenant will most definitely win that case, because the liability, the responsibility is actually ultimately on you as the landlord. So it makes sense for you to follow up your estate agent and find out how they are protecting your tenant's deposit, and make sure that they have done that within 30 days of receiving that the tenant's deposit. It's very, very important for you to be free of this particular law. Now, the deposit scheme, right, must be one that is recognized by the government. So you don't just take the tenant's deposit and go and pay it into what you call a special deposit account and say, oh, it's protected in there. No. The estate agent cannot even take a tenant's deposit and put it in a protected client account. No, that's not protection. It must be a government-recognized deposit protection scheme. And we have mentioned 3 of them already at the beginning of this broadcast of what tenancy deposit protection schemes are recognized by the government. Okay? Now, when you rent your property out to a tenant, right, as a landlord, within 30 days of receiving that tenant's deposit, there are certain information that you must give that tenant within 30 days of receiving their deposit. Now, number one on that information is you must obviously tell them the address details of the property. That's already on the tenancy agreement and all that, yeah. But then look at this once again. You must tell them how much deposits that they have paid. The tenant has a right to know how much deposits that you have taken from them and that you have put into deposit protection scheme. Number 2, you must tell the tenant how the deposit is protected. They must know who the deposit protection scheme provider is. Number 3, you must tell the tenant the name and the contact details of the deposit protection scheme that you are using. And you must also give them information about that deposit scheme's dispute resolution service. Every deposit scheme has a dispute resolution service, and your tenant has a right to know the details of their dispute resolution scheme so that they will know who to contact and how to contact them in the event of a dispute. You must also tell that tenant what your agent's details are, or your own contact details. Whoever they need to contact, if they need to contact the agent and the agent is responsible for the protection of the deposit, you must give them those details. If the agent has just done a job of finding you a tenant and handing the tenant over to you, and when the agent hands the tenant over to you, you must let the tenant know how to contact you, your contact details, your name, your address, your phone number. They have a right to know if you are the person who's going to be dealing with that tenancy. Now, remember, this information must be given to the tenant within 30 days of receiving their deposit. You must also tell the tenant why you are keeping some or all of their deposits. Now, this is really important because the tenant needs to know what that deposit covers. The tenant needs to know why they have to pay that deposit. You must make it clear to them that this deposit covers, say, damages in the property, and you must make it clear that those damages include cosmetic repairs like painting and the curtains and all that. Now, this is a very contentious issue, between tenants and landlords. What should be deducted from their deposit? Some tenants think that you should not deduct, from their deposit things like cosmetic repairs, like repainting the house, and unless the tenant has, maybe drawn a graffiti on the wall and really bastardized the wall, and then you want to charge them for that because that constitutes a damage. But sometimes reasonable landlords will know that, dirty paints or dirty wall is part of normal wear and tear of a property. If a tenant has lived in your property for say 5 years, and maybe they even have children, there's a possibility that those children will be, rubbing hands on the wall, or some marks on the wall and all that. As long as it does not constitute a major damage to the property, like a graffiti, that is part of the normal wear and tear. And then tenants and landlords do get into this kind of squabbles a lot of times, because they are saying, no, this is not a damage, this is normal cosmetic wear and tear, and that's part of the rent I've been paying to you. But if there are damages like, broken cupboards, broken windows, broken door handles, broken toilet seats, and all that stuff, you can tell the tenant, this is how much this is going to cost, and I'm going to charge that against your deposit, right? Or the tenant left the property very dirty, not cleaning it at all. The landlord can come and say to the tenant, I am going to charge you for cleaning this property because you were meant to clean this property at the end of your tenancy. So these are the things you have to arrive at, the conclusion and the arrangement and the agreement. You have to arrive with the tenant, and they must know what their deposit covers from the onset. It has to be clear enough to them. And if you do it from the beginning of the tenancy, it saves you a lot of stress and trouble with the tenant at the end of the tenancy. Okay? You must also tell the tenants how to get their deposit back. You must tell the tenant how to get their deposit back. At the end of the tenancy, this is how you're going to get your deposit back. This is the process. These are the numbers you're going to ring. This is how we're going to approach this. Right? They have to know. They have to have that knowledge from the onset within 30 days of you receiving their deposit. You must also tell the tenants what they will do or what they have to do if they cannot get hold of the landlord at the end of their tenancy. The tenants must also have that information, what they have to do and what they should do when they can't get hold of the landlord at the end of their tenancy. The other information that you must tell the tenant is what to do in the event of dispute. What happens when there's a dispute? What happens when we don't agree on how much is due back to you as a deposit? What happens when we do not when we have a dispute about how you're getting your deposit, how much you're getting? The tenant must know what to do if there is a dispute. They must know that there's a dispute resolution service provided by the tenancy deposit scheme provider that they have to make use of. And most of that dispute resolution service is free. And the tenant must also know it's a free service that they can get in touch with them, and then the both of you can go there and resolve your differences. Okay, so as a tenant, when your deposit is not protected, what do you do? Here are a few options for you when your deposit is not protected. When your deposit is not protected, the first thing you've got to do is to contact the landlord or the estate agent directly, either by writing them a letter, giving them a call, just sending them an email. But before you do that, it's important that you find out if your deposit is properly protected. So you can ring up any of these government deposit schemes, government recognized deposit schemes that we mentioned at first, Deposit Protection Service, My Deposits, or Tenancy Deposit Scheme. You can ring them up and find out if your deposit is properly protected. If they say that your deposit is not properly protected, you can then approach the landlord or the estate agent and say, hey, hang on a minute, I understand that my deposit is not protected or was not properly protected the way the law stipulates. Now, can we get this? Can we get a resolution on this? Can we agree, settle this amicably between us? Why this went wrong, what went wrong, and what, how I want to be compensated for that. Now, if you and the landlord or the estate agent cannot reach an agreement on that, you can then approach the court. You can approach your local county court. You can take your estate agent to court. You can take the landlord to court on the basis that your tenancy deposit was not protected or was not well protected. Because what happens is, when we say it's not even protected, not that it wasn't even protected at all. Some tenancy deposit schemes, some tenants deposit were protected later than the 30 days that the law stipulates. And if that is the case in your own issue as a tenant, if you find out that your deposit was protected after 30 days of the landlord receiving, or the agent receiving your deposit, you have a legal right to challenge it. You have a legal right to demand compensation. You have a legal right to complain. You have a legal right to raise a dispute. Okay, so it's not just a case of your tenants, your deposit not being protected. It's a case of your deposits being protected properly in accordance and in agreement with the law. Okay, so if you cannot reach an agreement with your landlord or estate agent, you approach your local county court. Be aware that there is a cost to that court arrangement. Now, if you are claiming some kind of benefits, you might get some discounts, or you might get that money written off. Like you might get some discounts on the court fees, right? But if you are not on any benefits and you have to pay the cost, if you win the case, that cost will be added to what the landlord or estate agent should be paying you. So you can recover your costs from the landlord or the estate agent. So when you go to court to present your case, there are a few things that the court can decide on. There are a few orders and pronouncements that the court can make in your favor if they find out that really and truly your if they find out that really and truly your deposit was not either protected or well protected. A few things that the court can decide in your favor is they can say that your landlord has to pay that deposit back to you. Okay, they might declare an order that the landlord has no right to hold on to that deposit. That deposit should be paid back to you and must be paid back to you, and the landlord or the estate agent must have to do that. The court might also decide that the deposits should be paid into a tenancy deposit scheme within 14 days of the court making the order. So if that deposit was not in a deposit scheme, the court can order the landlord or the estate agent to pay it into a tenancy deposit scheme within 14 days of that court order being made. The court can also decide in your favor that the landlord will have to pay you 3 times the amount of that deposit as compensation for not protecting your deposit or for not protecting it properly, right? And then they can also add the cost, the legal cost on top of that, and ask the landlord or the estate agent to pay that to you. At the end of your tenancy, if there is a dispute about protecting your deposit, it could also mean that the court can even say to you as a tenant, you shouldn't leave that property, you should remain in that property because the landlord refused or failed to protect your deposits, and they fail to protect your deposits appropriately. It's a ruling that the court can reach depending on the circumstances surrounding the case. So these are possible outcomes of your legal action. So we're going to call it a day here today, and I hope this has been useful to you both as landlord as a tenant. And please understand your rights, know your obligations as a landlord. Make sure you do things properly from the beginning of the tenancy so that you will avoid all these issues and all these troubles at the end of that tenancy. The aim here is to foster an arrangement and an agreement and a harmonious relationship between the tenant and the landlord or estate agent. Thank you very much for being part of today's program, and I hope to see you guys again next week. I remain your man, Ikenna Umezudike. God bless you all. Take care and goodbye. Bye now.